Contracts are the backbone of business relationships, protecting parties and clearly defining expectations. But how do you create an effective contract that stands up legally? A draft contract is a preliminary version of an agreement that outlines terms before final approval. It serves as the foundation for negotiation and eventual agreement between parties. While anyone can technically create a contract without legal assistance, understanding the essential elements is crucial for creating an enforceable document. For a contract to be legally valid, it must contain several key elements. These include contractual intent, lawful subject matter, a valid offer, valid acceptance, and an exchange of something valuable. In some cases, contracts must also be in writing to be enforceable. Different situations call for different types of contracts. Service agreements outline deliverables and payment terms between service providers and clients. Employment contracts define roles, compensation, and termination conditions. Partnership agreements specify ownership structures and responsibilities. Sales contracts govern transactions for goods or property. Non-disclosure agreements protect confidential information, and lease agreements establish terms between landlords and tenants. The contract formation process begins with an offer. Before acceptance, the offering party can revoke their offer, unless they've agreed to keep it open for a specific period through an option contract. The receiving party can accept the offer, reject it entirely, or make a counteroffer, which becomes a new offer requiring acceptance. Acceptance can be communicated in several ways: verbally, in writing, through performance of the exchange, by promising to perform, or through partial performance of obligations. When writing a contract, include basic information like party names, effective date, and a detailed description of goods or services being exchanged. Use specific language and well-defined terms to avoid ambiguity that could lead to disputes. Detail the exchange thoroughly, including descriptions, quantities, prices, and logistics. Include a termination clause specifying how and when the contract will end. For one-time exchanges, state that the contract terminates upon completion. For ongoing relationships, outline notice requirements for termination. Always address what happens if a party breaches the contract, including potential remedies. Avoid common drafting mistakes that can undermine your contract. Vague language creates interpretation problems. Missing key terms like payment schedules or deadlines leave critical gaps. Failing to include dispute resolution procedures can complicate conflicts. Contracts without clear termination provisions can trap parties in unwanted agreements. Ignoring compliance requirements may render contracts unenforceable. And without amendment provisions, making future changes becomes difficult. Finalizing a draft contract involves several important steps. Begin with internal review to ensure the contract meets expectations. Consider legal review by an attorney to verify compliance and protect your interests. Negotiate and amend as needed based on mutual agreement. Once all parties are satisfied, sign and execute the contract to make it legally binding. Finally, store the signed documents securely for future reference. A well-drafted contract serves as protection for all involved parties, clearly defining rights and obligations while minimizing potential risks. By understanding the essential elements and following proper drafting procedures, you can create contracts that effectively serve their intended purpose and stand up to legal scrutiny.